When were Tilak and Gandhi tried under the sedition law? Welcome to Inventiva, I'm Oishi Banik, back with a new story. The sedition law, which is enshrined in section 124A of the Indian Penal Code (IPS), was introduced by the British government in 1870 to tackle dissent against colonial rule. On Thursday, while hearing a petition filed by Major General S.G. Vombatkere, who has challenged section 124A of the IPC, which deals with the offence of sedition, Chief Justice of India N.V. Ramana observed that the colonial law was used by the British to silence Mahatma Gandhi and Gangadhar Tilak. In his plea, Vombatkere has challenged the constitutional validity of the sedition law on the grounds that it has a chilling effect on speech and possesses an unreasonable restriction on the fundamental rights of free expression. Therefore, his plea wants that law be struck down. Article 19(1)(a) of the Constitution guarantees Indian citizens freedom of speech and expression. The sedition law has been challenged several times over the last few years, but it has managed to survive all the challenge against it. In the landmark case of 1962, Kedarnath versus Union of India, the Supreme Court upheld the constitutional validity of the sedition law while trying to curtail its misuse. The court said at that time that unless accompanied by an incitement or call for violence, criticism of the government cannot be labelled sedition. When was sedition law introduced in India? The sedition law, which is enshrined in section 124A of the Indian Penal Code, was introduced by the British government in 1870 to tackle dissent against colonial rule. The original draft of IPC, which was enacted in 1860, did not consist of this law. Section 124A states the following: whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, or with imprisonment which may extend to 3 years, to which a fine may be added, or with a fine. A blog published by the Library of Congress notes that in the 19th century and 20th centuries, the law was used primarily to suppress the writings and speeches of prominent Indian nationalists and freedom fighters.